This order lays out corruption by Fani Willis, secrets and lies to hide records about her collusion with the Pelosi January 6th committee. So if you've been following Judicial Watch and me on social media recently, you've been tracking, and of course our weekly updates, our lawsuit against Fani Willis for records about her collusion on the targeting of Trump with the Biden gang, specifically Jack Smith, and the Pelosi January 6th committee. We asked her repeatedly for records. They denied having any such records. Turns out they had at least one. They kind of had to admit to it. They still refused to produce records, pretended they didn't have anything, didn't even bother to show up in court and respond to our lawsuit. She was found in default by a local court in Georgia. And as a result of that, I can announce to you that she was ordered by a court just the other day to pay within 2 weeks, her office, nearly $22,000 to Judicial Watch. And here's our press release. Court awards Judicial Watch $21,578 in fees and costs in open records lawsuit against Fani Willis. And this is the ruling, order granting attorneys' fees and costs. I'm going to read a good part of it to you because, again, Fani Willis is one of the top abusers of President Trump and many other innocent Americans down there in Fulton County. Has she and her colleagues there, as I say, in league with, because it's been confirmed, by the way, she does have documents showing collusion with Nancy Pelosi's January 6th committee to get Trump and who knows who else. It's been confirmed as a result of our lawsuit. So she's one of the top abusers of the First Amendment in that regard, because it's a retaliation for exercising your First Amendment and other civil rights. So Judge McBurney, who is in the Superior Court of Fulton County, issued the ruling, dated January 3rd, so it was last Friday, late Friday. Plaintiff submitted an Open Records Act request to a defendant on August 22nd, 2023, by way of Fulton County's ORA online portal, ORA, short for Open Records Act. That same day, plaintiff received confirmation that its request had been delivered and would be channeled to the appropriate department, presumably the district attorney's office. The following day, the county's open records custodian sent plaintiff, Judicial Watch, an email confirming that the district attorney's office had received the inquiry and asking Judicial Watch to simplify its request. Literally 5 minutes later, before any simplification had occurred, so we didn't have a chance to respond, the plaintiff received a second email from the records custodian. After carefully reviewing your request, we do not have the responsive records. The response was perplexing and eventually suspicious to plaintiff Judicial Watch, given that Judicial Watch subsequently uncovered through its own effort at least one document that should have been in the district attorney's office possession that was patently responsive to the request. And this was a letter signed by Fani Willis herself to Benny Thompson, the then chairman of the January 6th Rump Committee. The discovery prompted the current litigation filed in March of 2024, seeking an order directing defendant to comply with the Open Records Act and provide all responsive records. During the pendency of the litigation, defendant three more times, denied the existence of any responsive records, once in a request for admission and twice via answers to interrogatories. So that was under oath. Every time we have searched and there is nothing. That wasn't true. Defendant ultimately defaulted, and this court entered an order on December 2nd, 2024, directing defendant to conduct a diligent search of her records for responsive materials and to provide any responsive records that are not legally exempted from disclosure. If defendant, excuse me, my cough is coming back. If defendant elected to withhold all or part of any responsive records, she was further directed to comply with the OCGA Section 50-1871D by identifying the bases for the withholding. Defendant's compliance with the court's order consisted of an undated, unsigned, 2-page memo to plaintiff from defendant's, quote, open records department. Really not sufficient. Not sufficient at all. In this memo, defendant announced that there were still no records responsive to one set of plaintiff's requests, communications with former Special Counsel Jack Smith. We don't believe it. But there were, in fact, records responsive to plaintiff's second set of requests, communications with the United States House January 6th Committee. But those were exempt from disclosure. Defendant, despite these reservations, did gamely attach to her memo a copy of the letter she wrote to the chairman of the House Committee that, one, does not appear to be covered by any of the exemptions identified in the memo, and two, had already been identified by plaintiff, Judicial Watch, as a responsive record that was wrongly withheld. So that's the letter we were talking about earlier that Fani Willis had signed to the head of the January 6th Committee, Benny Thompson. Somehow something had changed. Despite having previously informed plaintiff 4 separate times, and the court emphasizes 4, by the way, that her team had carefully searched but found no responsive records, now there suddenly were, but they were not subject to disclosure under the Open Records Act. Plaintiff's deposition of defendant's record custodian shed some light on the mystery. So our lawyers recently deposed an official in Fani Willis's office about the search for records and the response to our request. He admitted there was no search for records back in August of 2023. So they told us they had nothing without looking, or that's what he testified to. Just a no go away, quote. He further clarified that when plaintiff did not go away but instead sued, there still was no organized, comprehensive examination of the district attorney's office, office's records. That would await the court's December 2nd, 2024 ruling. That's the one in which she was found to default, and Fani Willis was ordered again to search for the records and give any that were releasable to Judicial Watch. The Open Records Act is not hortatory. It is mandatory. Non-compliance has consequences. One of them can be liability for the requesting party's attorney's fees and costs of litigation. To recover its relevant and reasonable fees and costs under the Open Records Act, plaintiff must do 2 things. First, it must show that the defendant violated the Open Records Act. Second, plaintiff must also demonstrate that the defendant lacked substantial justification for the violations. Here, plaintiff, Judicial Watch, has done both. Most basically, by operation of law, defendants acknowledge violating the Open Records Act when she defaulted. But actual evidence proves the same. Per her record custodian's own admission, the district attorney's office flatly ignored plaintiff's original Open Records Act request, conducting no search and simply and falsely informing the county's open records custodian that no responsive records existed. We now know that it is simply incorrect. Once pressed by a court order, defendant managed to identify responsive records, but has categorized them as exempt. Even if the records prove to be just that, exempt from disclosure for sound public policy reasons, this late revelation is a patent violation of the Open Records Act. And for none of this is there any justification, substantial or otherwise. No one searched until prodded by civil litigation. Judicial Watch. Given this, the court finds that relevant and reasonable attorney's fees and costs of litigation are properly awardable to plaintiff pursuant to the law. The evidence from the court's December 24th hearing, there was a hearing that we showed part of to you a few weeks ago, just shortly before Christmas, where we had a hearing on our attorney's fees and costs. The hearing on attorney's fees showed that the plaintiff's counsel's billing rate is reasonable and that the items for which he billed, for the most part, relevant to the defendant's Open Records Act violation. From the record made at the December 24th hearing, the court finds that the plaintiff incurred $19,360 in attorney's fees related to plaintiff's efforts to enforce compliance with the ORA. Related litigation expenses are $2,218. Defendant is thus liable to plaintiff for $21,578 pursuant to, and he cites the law. That amount shall be paid within 2 weeks of the entry of this order, so ordered this 3rd day of January 2025, Judge Robert C.I. McBurney, Superior Court of Fulton County, Atlanta Judicial District. So this order lays out corruption by Fani Willis, secrets and lies to hide records about her collusion with the Pelosi January 6th committee, records which she continues to hide to this day. So she has to give us this money within 2 weeks, and obviously, we don't gladly take the taxpayer money at issue here. I think there should be an investigation of what went on in this records case as part of the investigation of her illicit, in my view, targeting of Trump that I've been talking about in terms of that should be subject to federal and state criminal investigation potentially for the violations of civil rights under color of law. And then, of course, we still, despite getting this $22,000 nearly from the court or through this court order, we still want the documents they're withholding. And we've asked the court for a special master, which would be a special court, someone with authority under the court to monitor and basically manage the search for records. We've asked the court to look at the documents that have been withheld as well to see if the withholdings they're citing or the exemptions they're citing as justification for withholding the records are sufficient and warranted, and whether we should get the records or not. I mean, our goal in the end, this isn't about the money, this is about getting the records. Now, we still don't have the details, but we do have confirmation from Fani Willis's office, as described in this court record, this court order, that she had communications. She was, quote, colluding, as I call it, unquote, with the Pelosi January 6th committee in her Get Trump efforts. Remember, she tried to, now the case against Trump is dead, practically speaking, down there, but the case against others continues. She's been removed from the case for other misconduct related to the hiring of her boyfriend to pursue Trump. And on top of that, you've got this record scandal. And this shows you the importance. I know sometimes FOIA and open records laws and things kind of like, you're getting records, who cares? Well, in this case, it exposes a scandal. The records expose a scandal and confirm a scandal. They lied to us. Looks to me like they were lying to the court. I mean, the court's kind of being nice here. And not only is this going to uncover these records confirm corruption by Fani Willis, where else do they confirm corruption? By the Pelosi Congress. The January 6th operation that corruptly targeted Trump and smeared him, and they abused the powers of Congress to interfere in the election and target enemies of Joe Biden and the Pelosi regime. And this collusion, which everyone suspected, was confirmed not by Congress, not by the media, not by a law enforcement officer, but by Judicial Watch. And again, I thank you, Judicial Watch donors, those of you who are supporting Judicial Watch, for allowing us to do this work, because, I keep on saying that, we've got to be in court in order to get this work done, and we can only do it with your support. So if you're not supporting Judicial Watch, I encourage you to do so. And, our persistence, our willingness to go to court and stick with it. I mean, this began nearly 2 years ago. And we're still fighting for the records. I mean, we just got an acknowledgement the records existed. It was like pulling teeth, obviously. I mean, we were facing lies by government officials to prove the existence of these records. But Judicial Watch's heavy lifting once again got results on behalf of the rule of law. So I'll keep you updated. Her response to our request for a special master, Fani Willis's response, is due soon. I think it's almost due. I think it's probably due now, more or less. And then the court has to decide how he's going to handle the dispute about A, the documents, and B, whether they did a real search. Because it looks like they didn't search cell phones or text messages or anything. So this case, we're not at the end of this case. I'd say we're to the early part, middle of the case. And so we need your continued support. And if you don't support us financially, you can pray for wisdom and discernment for those involved. And also, you can share the information I'm sharing with you now to your friends on social media and elsewhere and educate them about the importance of uncovering the abuse of Trump that took place in Fulton County, Georgia, in a way designed to upend, as I've noted, our constitutional republic. Thanks for watching. Don't forget to hit that subscribe button and like our video down below.